The next case is Uecker versus Uecker. Each party will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes. How long would you like to reserve?
I'll reserve 5 minutes, Your Honor.
Okay, very good. It's now the top thing will be running down. When it gets to 5, that's when your time is up, if you're looking over at our clock over there.
Okay.
The arguments are being recorded, so first please introduce yourself when you come up to the podium. Please make sure that you stay behind the podium. We're recording you, so make sure you don't get off the video. And secondly, please make sure you speak in a normal voice, so it can be easily heard and recorded. I don't believe in this case we'll have any issues of names of children, of minors, or anyone like that. But if you would, please use a name like the child or initials for the child you're referring to. Judges have read your brief and are ready to proceed whenever you are.
Good morning. May it please the court, my name is Adam Morris on behalf of the appellant, Juliana Uecker. Your Honors, this case is about the finality of a divorce decree. And there's a long line of cases that discuss how these divorce decrees need to be final and they should not be subject to modification after the decree of divorce is finalized and the parties enter into their agreements. In this case, Your Honors, Ms. Uecker and Mr. Uecker were divorced in 2007. They agreed upon a division of property. And in that division of property, Ms. Uecker was awarded 100% of the Burt Bell, Pete Rozelle NFL player retirement plan. Mr. Uecker was a former NFL player, and as part of his divorce, he negotiated to give her 100% of that plan. In exchange, he received a commercial building located in Florida. This was the deal the two of them made.
And this was addressed a little, but it was still, to me, I still had some more questions. The property that he received in Hollywood, Florida, okay, the business or whatever it was, that was valued at a certain amount, and the pension was valued at a certain amount in 2007?
Yes, Your Honor. Yes, they did do the values as of that date. And both parties agreed to assume those assets or retain those assets. And as this court knows and everybody knows, that assets have a changing nature. Assets go up in value, they go down in value. That's the assumption of the risk of taking an asset in a divorce. And as Ms. Uecker had James Myers from Kudrow Group, Kudrow Consultants, come and testify as her expert. As he testified, he doesn't usually do these offsets. And the reason why is because things can change. And Ms. Uecker accepted the risk of loss associated with this retirement plan.
Well, does it matter who the retirement plan is with? Because there was not much risk of loss with the National Football League, right?
There could have, there could be, there could not be. Nobody knows. I mean, it could be argued that there couldn't be a risk of loss with you know, a car maker 20 years before the car maker went under. But that risk did come. And nobody knows what could happen to the NFL. But there is some risk involved with assuming that asset. Maybe that risk was minor, it could have been. But she did have that risk of loss. She should also have the benefit, if there's any benefits that are added onto that plan. And in 2007, there was one benefit. Okay, we all acknowledge this. There was the benefit credit pension plan. That was the primary benefit under the retirement plan. There were some other benefits, disability benefits, and there's an expansion benefit, but the primary benefit was this benefit credit pension plan. She was in, the interesting thing about this decree is this decree didn't just give her that benefit credit pension plan. It gave her 100% of the retirement plan. So the whole umbrella retirement plan. And if these parties were trying to specifically carve out that she was only gonna get that pension plan, they could have done that. But in this case, they did not. They gave her 100% of the retirement plan. In 2011, the players negotiate a supplemental plan, or a supplemental benefit that falls under that retirement plan. And I think everybody acknowledges here that that benefit is under the retirement plan. That was a supplemental benefit that Ms. Uecker should receive 100% of. She took on the retirement plan as her asset, he took on the building, and one good example is, let's say with his building, he all of a sudden gets a fantastic tenant that shows up after the divorce decree. He would get the benefit of that tenant. He would get the benefit of any windfall that happened to that building. She should receive the same benefit. And that's all that she's asking, is that she receive all of the benefits that fall under the Burt Bell retirement plan. And if you look at the case law that was provided in the brief, there's three main cases that we point out to. That's Straw, which is a 9th District case, there's Cutterell, and there's Jewett. And all these cases involve supplemental benefits. And what the court did was they followed the terms of the divorce decree, and they said, and some of these are right on. These cases talk about accrued benefits as of the date of commencement of receiving the benefit. They decided here in these divorce decrees, we've equally divided the benefits, therefore we're going to equally divide the supplemental benefits. In this case, Ms. Uecker took on or retained 100% of the benefit, and the trial court didn't say you get 50% of the benefit, the trial court said you got 20% of the benefit. Which doesn't even, it just does not make sense when you look at the case law. The trial court did not have the ability to modify the property division in this case. There was a QDRO that was put in place. Okay, and this may, become a question. That QDRO was not correct. That QDRO was an error. And why was that QDRO an error? Because that QDRO modified the terms of the separation agreement. In that QDRO, they say that Ms. Uecker should only receive the benefits that accrue as of the date of that QDRO. That's not what the separation agreement said. The separation agreement said that she receives 100% of the benefits as of the date of the commencement of the benefits, which happened in 2018.
Well, if a QDRO is wrong and doesn't reflect what the actual settlement agreement provides for, what is your remedy?
Well, the remedy, and there's plenty of case law on here, the court retains jurisdiction to modify that QDRO. And as...
Indefinitely?
Indefinitely. And the court retained jurisdiction in this case to modify that QDRO. And there's specific language, there's continued jurisdictional language, which talks about if there's a change of benefits. They have the ability to modify that QDRO. And the case law says that a QDRO cannot modify, reduce, enlarge the benefits that are provided in a separation agreement. Okay, so that's the starting point. Is this QDRO is not permitted to do that. And the case law is that the court should modify that QDRO if it does that. And that's essentially what we've asked this court to do.
Well, I guess when I asked about the remedy, I was just getting a little confused. I think about stuff as I'm sitting here, so I'm trying to figure out if the QDRO is definitely wrong, okay? So you can sit on the QDRO for 30 years until retirement becomes effective, then say, oh, by the way, this QDRO is wrong.
Well, yes, you can. And the QDROs, the plans are changing, right? All retirement plans are constantly changing. And QDROs, as Mr. Myers testified, he's they're constantly doing supplemental and modified Q-droves to reflect the changes in the plans. And retirement plans are just, they're like this retirement plan, they're molding, they're changing, laws change. So the Q-droves need to be modified as the law changes so that the parties can receive the benefits they received in the divorce decree.
And I can see that, but I guess what I'm asking is, this Q-drove was wrong from inception, though, is what you're saying.
Yes, the Q-drove from inception did not comport to the terms of the separation agreement. It did not have the same language as the separation agreement.
Just as, I'm sorry for
Oh, yes.
apologizing, but as I said to somebody before, I've sat with 3/4 of the judges here on the wall, so I'm very old, so I can tell you, that was one reason why this court always said it wasn't a final appealable order until the Q-drove was filed, because that way everybody could take a look at it and then appeal and say either this is a wrong from inception or it's not. And obviously the Supreme Court told us many, many years ago that was incorrect, but anyway, you can proceed, that's just me. Maybe Judge Stevenson can give you 15 extra seconds.
And you are in your rebuttal time. If you want to continue, you may, or you can save the rest of your rebuttal time.
Just as I can, I just want to just finalize that point. The purpose of the Q-drove is to implement the terms of the decree. And that's why the Q-droves can be modified, and that's why the Q-droves can be supplemented, and that's why we have these tools in place. The decree is like that's set in stone, that's the frozen document. These Q-droves are just to implement, just like courts are constantly issuing new orders where they have the ability to, where the parties retain jurisdiction. And that's exactly why the parties retain jurisdiction in the divorce decree, and they actually retain jurisdiction. There's a continuing jurisdiction provision in the Q-drove also. So I will reserve the rest of my time for rebuttal. Thank you, Your Honor.
Thank you. When you're ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is Rachel Smith, and I represent the appellee, Richard Uecker, in this case. Opposing counsel got up and had briefly summarized the facts for you. Just to reiterate, the parties were divorced in 2007. As part of the decree of the divorce, wife was awarded 100% of husband's retirement benefits under the Burt Bell retirement plan. However, if you look at the language of the decree, her ownership of defendant's retirement benefits were to become effective on the date that the judgment entry or decree of divorce was filed with the court. This was back in August of 2007. Subsequently to that, there was the Q-drove that was filed. That was in October of 2007. And the Q-drove said that she is to receive 100% of his accrued benefits under the retirement plan, effective as of the date of this order, and the terms of the plan in effect as of the date of this order. Meaning wife's benefits received under the plan were frozen as of October 2007. That is different than the language in the decree, because the decree says that her benefits are assigned as of the date of the decree. The Q-drove says that her benefits are assigned as of the date of the Q-drove. Lo and behold, 4 years after the parties were divorced, in 2011, pursuant to a collective bargaining agreement reached between the current NFL players and the NFL created a separate and distinct new benefit for the retired players, and that's called the legacy pension benefit. Those benefits did not exist at the time of the parties' divorce in August of 2007, nor did they exist at the time that the parties filed that Q-drove in October of 2007. Instead, this is an entirely new benefit that was created 4 years post-divorce. Then in 2020...
But nonetheless, it was for the appellee's time that he's in the NFL.
It was for 4 out of 10 years of his service in the NFL is what they were married for. So she would have been entitled to 20% under the coverture fraction and Hoyt, obviously. But pursuant to the terms of this decree, obviously the parties had negotiated the values of their assets, debts, and liabilities as of 2007 and found that awarding wife 100% of husband's benefits under the NFL plan as they existed in 2007 is what was an equitable result as of 2007. Then in 2020, 13 years after the parties had divorced, husband learned of this new legacy pension benefit that was available to him. He inquired, he called the NFL was the plan administrator, he had the QDRO on file. He called the NFL and inquired as to whether those benefits were included in the original retirement plan or not. And he was assured that those benefits were separate and apart from the original benefits that wife was awarded 100% of pursuant to the 2007 decree. Then in July of 2021, that's when wife filed the motions requesting that husband be held in contempt of court for not conferring the benefits to her. Husband filed responsive motions indicating that the legacy benefits were not retirement benefits pursuant to the decree because they didn't exist at the time of the decree. They didn't come into existence until 4 years after the decree. The matter proceeded to trial in August of 2022, and the court issued a judgment entry finding that 80% of the benefits should be entitled to former husband and 20% should be allocated to former wife, using the coverture fraction. Wife takes its appeal, erroneously contending that the trial court committed an error and abuse of discretion by modifying the decree of the terms of the separation and failing to find that Juliana was entitled to receive 100% of the benefits under the retirement plan, including the new legacy pension benefits that did not exist at the time of the decree. In this, the trial court didn't make any error. The trial court did not modify the terms of the separation agreement. Instead, the trial court properly used its discretion in clarifying the terms, the ambiguity in the decree and in the QDRO, in light of this newly created asset that came into existence 4 years after the parties' divorce, in an effort to equitably divide the new marital asset that was not contemplated by the parties at the time of the divorce. We understand that 3105.171 prohibits a trial court from modifying the previous property division. However, as opposing counsel had explained, a QDRO is merely an aid in execution. As stated in Wilson v. Wilson, a QDRO implements the court's decision of how a pension is to be divided incident to a divorce or a dissolution. And if there's good faith over the interpretation of a decree, the trial court enforcing that decree has the power to hear the matter, clarify the confusion, and resolve the dispute. In this case, everyone agrees that wife was awarded 100% of the retirement benefits as they existed in 2007, and that is according to the language of the separation agreement. 100% of the benefit credit pension remains intact and is ready for the taking as soon as wife commences her benefits under that plan. Husband's expert, Al Miner, the actuary, testified that in 2007, the total value of the plan was $295,000. Al Miner testified that the total value at the time of trial in this matter in August of last year was $470,088. So the total value of the asset wife did retain did increase. It increased by about $175,000 from the date of divorce to the time of trial in this case. Nobody disputes that wife is 100% entitled to all of those assets. The key differences in this case is the differences between the benefit credit pension and the legacy pension benefit. Husband's expert, Richard Nagel, reviewed all of the terms of the plan documents from 2001 to 2007 when the parties divorced, 2014, various 2021 iterations of the plan, so on and so forth. And he went through and he testified that at its inception in 2011, the collective bargaining agreement puts the benefit credit pension in a completely separate article and category than the legacy pension benefit. This is the creation of this benefit. And in the article, I believe it was Article 57 of the collective bargaining agreement, no, sorry, it was Article 53 of the collective bargaining agreement, states that the benefit credit pension will remain intact, but no further benefits will accrue under that provision. Now, the plan was later modified, collective bargaining agreements, things changed after that. But at no point was the benefit credit pension tied to the legacy pension benefits. And that's important because it shows that these two benefits are completely separate, they're not interrelated to one another, and they're not merely, the legacy benefits are not merely a supplement or an enhancement for the original pension benefits under which wife was awarded. As Mr. Nagley had testified, the plan calculates these as two separate benefits using two separate calculators with some outliers. The plan pays the benefits at separate times. 2 separate checks are issued. You can elect to receive these benefits in different manners, in different forms, in different methods. One could be a life annuity. The other one could be a survivorship annuity. They are completely separate from one another. Benefits can commence at 2 separate times using 2 different benefit applications, which is exactly what happened in this case. Because husband commenced his legacy pension benefits under a life annuity, whereas wife benefits still remain intact. Nothing has changed from wife's original award. So wife would like everyone to believe that this is merely a supplement to those benefits, but that's not the case. If you look at the benefits that are discussed in the 3 cases cited by opposing counsel, Jewell, Straw, and Cottrell, those all dealt with supplemental benefits from early retirement and the like, where the opposing spouse retired early, they're receiving a basic benefit and a supplemental benefit on top of that. That's not the case with this NFL retirement plan. Even Mr. Nagley had testified that after doing this for 33 years, he had never seen a plan like this throughout the history of his career. So the trial court was correct in finding that the legacy pension benefits is not a supplement or a part of the benefit credit pension, that it's a new and separate benefit that's not a remainder of the benefit credit pension in any way, shape, or form. The benefit credit pension remains intact. The trial court was correct in finding that the decree provided language that reserved jurisdiction to establish and or maintain the qualified assets of the order and to effectuate the intent of the parties as stipulated. Everyone also agrees that according to the terms stated in the separation agreement and the QDRO, further orders from the court are required in order for wife to receive any portion of the legacy pension benefits. Much like this court's recent decision in the Jaworski versus Jaworski case, I probably pronounced that wrong, neither the divorce decree nor the QDRO distinguish between contributory and non-contributory of husband's retirement benefits. Much like in this case, it's clear that neither the decree or the QDRO distinguish between benefit credit pension and legacy pension benefits. Also similar to Jaworski, both experts agree that the QDRO would need to be amended to award wife any portion of the legacy pension benefits, in addition to what she's already receiving under the current documents, which is only the benefit credit pension. A change in the QDRO to reflect what wife wants this court to do, which is award her 100% of the benefit, would be changing the original decree and the stipulated QDRO, and would also award a windfall to wife of an entirely new asset that did not exist at the time of the decree. Similar to Jaworski, changing the original QDRO to reflect such a distinguishment constitutes a modification of the decree.
But you didn't cross appeal, right? So as the court's order stands right now, it's 80-20.
Yes. Yes, that was our position at trial. Here we are now.
Understood. Okay, thank you.
We believe that the trial court did not make any error in following the well-established case law that in the event of an ambiguity, it's up to the trial court to interpret the documents in fairness and in equity. Those 2 key terms are what's most important in this case, because everyone agrees that at the time of the legacy pension, or everyone agrees that the legacy pension did not exist in 2007, and as such, the value was 0.
Did the trial court find this decree was ambiguous?
The trial court found that the language in the decree did not match the language in the QDRO, and that the legacy pension benefits were not included in either. So the court, in
So
attempting...
it did specifically make a finding of ambiguity one way or the other?
No, there was no, the court finds the following phrase as ambiguous, or what have you.
Do you think this is ambiguous?
What?
Do you think this is ambiguous, this decree, or is this asset just a different asset that wasn't included at the time of drafting the decree?
I think it was an asset that was not included at the time that the decree was drafted. However, I think that the court could be fair in finding that the wife was awarded the benefits in the plan as of 2007, and then finding that these benefits were accumulated during the marriage, and in order to effectuate the intent of the parties pursuant to the decree, which would be to divide everything equally, that a coverture fraction is what would be appropriate.
Was the only matter pending before the court the hearing contempt file that wife had made. Was there any other motion filed after that to ask the court to divide this asset at some capacity?
Wife had filed a motion for contempt for failure to sign over and transfer all the retirement benefits, a motion for contempt of court for failure to inform plaintiff of defendant's constructive receipts, for an order requiring defendant to immediately reimburse plaintiff to the extent of the received benefits under the plan, a motion for contempt for defendant's violation of Article 9 of the final decree of divorce, and a motion for an order determining that plaintiff is entitled to 100% of the retirement benefits in addition to an award for attorney's fees. Husband had filed responsive motions, basically essentially explaining that he can't be held in contempt for failing to give an asset that isn't included in the divorce and didn't exist at the time of the divorce. And thereafter, the litigation.
Well, responsive pleadings and not necessarily responsive motions. So you
No.
just file a motion, say
No,
no.
husband didn't file anything to say, amend the decree or adopt a different Qdro or anything of that nature. So we believe that the trial court was correct in holding that the legacy pension benefits are marital asset. They were accumulated over 10 years of husband's NFL career. 4 of those 10 years, husband was married to wife. This whole asset did not exist at the time of the decree. We believe the trial court was correct in following the intent of the parties and dividing this asset using a coverage refraction rather than awarding wife 100% of this newly discovered asset that was not and could not have been contemplated by the parties in an equitable division of marital property in 2007 because it didn't exist. Wife complained that there was a Florida property in exchange for this, but the decree doesn't say that, and that's also noted in the judgment entry. Therefore, we request that this court uphold the trial court's decision and enforce the order regarding the legacy pension benefits. Thank you.
You don't have any remaining time for rebuttal when you're ready.
Your Honor, how much time is that?
3:39.
3:30, okay, thank you, Your Honor. Your Honors, there was some discussion by Appellee's counsel about wife received 100% ownership of the plan as of the day of divorce. That's absolutely correct, and that is the point, is that she received 100% ownership of the retirement plan. She received 100% ownership of any benefits that derive from that retirement plan. And now, Mr. Uecker is attempting to come back and claw back some of those benefits that derived under that retirement plan.
Well, the question to me is this retirement plan, does this benefit that exists now come into existence because of the retirement plan or because of the new collective bargaining agreement? So is it something brand new or did it exist in 07?
The benefit, the pension, the legacy credit pension did not exist. But it is a pension that is part of the retirement plan. And it's a benefit, it's a supplemental benefit that is part of the retirement plan. If you look at the forms that the NFL files with the government, and that's one of the exhibits, the Form 5500, they explain the retirement plan has these three benefits: the benefit credit pension, the legacy credit pension, and the expansion pension. So even though it's a benefit that came into existence after the divorce decree, it is still part of the retirement plan that she was to receive 100% of. There was no 60B that was filed in this case. Nobody asked the court to modify the property division. Potentially, if a 60D was filed, I don't know if the court would even have the ability to do anything, and that would be a separate issue. But as one of the questions was asked by this court, there was no request to modify the property division in this case.
Although pending was your motion for contempt and some other assorted motion, give me the money back, I didn't receive that sort of stuff.
And a motion to modify or the QDRO,
Okay.
which is probably the most important motion. That's the request we submit a supplemental QDRO, and we wanted the court to adopt the supplemental QDRO. The trial court decided that they were not going to do that, and they ordered a separate supplemental Q-Tro. That's the interesting thing, is they did order the parties to file supplemental Q-Tro, but with the 80-20 split.
So kind of like a motion to modify child support that goes against your client, the court's view was I had the authority to modify the Kruger because you guys asked for it to be modified, so I can modify it anyway, I should.
I would say that was her argument in her decision, and Judge Ortel's decision, is that she believed that the court had continued jurisdiction to modify it however she wishes to modify it. But that's not what she had the jurisdiction to do. She had the jurisdiction to enter in a correct Q-Tro that reflected the terms of the divorce decree. And the correct Q-Tro would say that she receives 100% of the accrued benefits as of the commencement date of the benefits. And that's all we're requesting, is that Q-Tro be implemented, that husband, or that Mr. Uecker cooperate with that Q-Tro, and that our client receive anything that she should pay that she should have been receiving under the terms of that plan.
Of course, I know you're out of time, Judge Carr said give you extra time because she was talking. I'll give you a small amount of extra time to conclude.
I just need 10 seconds. The interesting thing is, Mr. Uecker's own expert, Mr. Nagley, said that if this is a retirement benefit, this should go to Ms. Uecker. So their own expert agreed that if the court determines this is a retirement benefit, it should go to Juliana Uecker, and the trial court did determine that it is a retirement benefit. Thank you very much.
And I thank both of you for your presentations today. The court will take the matter under advisement and make the decision in due course. The clerk of the court will mail a copy of that decision to us with relief, and it'll also be released to the High Supreme Court's website. Thank you both very much. We are now adjourned.